Advocate Ramosepele courtroom submissions session delivered a poetic twist. The same hearsay framework that the state once leaned on has now circled back, with Advocate Ramosepele using it to pin Baloyi in a legal chokehold. This wasn't just an argument. It was a lesson in how lawfare can boomerang. In a composed but sharp submission, Advocate Ramosepele reminded the court that the state itself relied on executive statements and common purpose theory to admit certain material earlier in the trial. But now, Baloyi wants to cross-examine Muzi Sibiya based on Ntanzi's statement, a statement Sibiya never made. That's when Ramosepele exposed the trap. If the state wants hearsay from another accused to apply to Sibiya, they must make an admissibility application. There's no shortcut. Yet, that application was never made, not before they closed their case. Not at all, meaning the state laid the foundation for hearsay reliance, but failed to build the walls, and now those missing walls are collapsing on Baloyi. Ramosepele argued that Baloyi's attempt is not only procedurally defective, but self-damaging, because it exposes the state's earlier failure to secure proper admission. In short, you can't now use what you never legitimized. Let's quickly dive into court and watch this dramatic moment, Ramosepele turning the tables.
We say, my lord, that a statement made by an accused which falls short of a confession but amounts to an admission or other statement by the accused concerning his co-conspirators is as admissible against the latter, provided that it was made in furtherance of a common purpose. Now, the issue that I want to touch on, that's why I refer to this document, my lord. It's what Advocate Baloyi now says that if the executive statement exception is not applicable, the alternative is that the Hearsay Evidence Act must apply, so that Exhibit JJ and the other exhibit, which are statements of allegedly of Mr. Ntanzi, must apply to the co-accused. And we say, my lord, the question, therefore, is whether the Law of Evidence Amendment Act allowed the introduction of such statement and whether it is constitutionally sound. If so, a further question arises regarding whether the admissibility of such statement is to be determined. Firstly, we say, my lord, the Law of Evidence Act, the Hearsay Act, did not in its terms purport to change the substantive rules of relevance. And we say, my lord, that the Ndovu case that we cited, which was disproved by Litago, concerned itself exclusively with the application of the Hearsay Evidence Act and found that there were sufficient extraneous factors or evidence to ensure reliability of the extracurricular statement. The court in Ndovu was not asked to consider whether the Law of Evidence Act expressly or by necessary implication extended the rule of reliability, which excluded any admission made by one conspirator against the other beyond the case where the statement was made in furtherance of a common purpose. Now we deal with what Mr. Baloyi seeks to do, that is to be allowed to cross-examine Mr. Sibiya on the evidence on the alleged statements made by Mr. Ntanzi. My lord, I must say that I was taken by surprise yesterday when Mr. Baloyi stood up and said he wanted to...
Who's that?
When my learned colleague, Mr. Baloyi,
Okay.
said he wanted to refer statement to Mr. Sibiya, which is a statement allegedly made by Mr. Ntanzi. And he wanted to cross-examine him on that because, my lord, we've had a trial within a trial in this matter. And at the trial within a trial, in respect of Mr. Sibiya in particular, when that statement was introduced, the state indicated that we are introducing this statement so that it is binding against the maker. At no stage where the other co-accused precognized to say, should the court admit this statement as evidence, then the rest of you, this statement is going to be applicable to you. Then it will give the other co-accused the chance either to challenge or to acquiesce with the statements made by Mr. Ntanzi. Now, to come up in cross-examination and to say, now that the statements are admissible, I'm going to refer you to this statement to bind you and to bind the other co-accused because this is an executive statement. And by the way, my lord, I submit without contradiction as well, that this is not an executive statement, and I'll show why I say that this is not an executive, those are not executive statements. And I'm also not going to give them a classification to say what they are, because the court has not indicated yet whether these are confessions or admissions. So I'm not going to be brave to say this is a confession, this is an admission. Now, to use the civil term, my lord, we say, at the time when the state says, I'm going to introduce, for example, JJ to bind you, Mr. Ntanzi, the term in civil law to say there was no lease between not rental agreement, LIS, to say, Mr. Ntanzi, once your statement is admitted, I'm going to use it against Mr. Sibiya. I'm going to use it against Mr. Mngube, Mr. Mapisa, Mr. Ntuli, so that their lawyers could take the necessary legal routes to protect their client's rights regarding those statements, my lord. And with VEV, my lord, Kappa versus S is not applicable here because it puts a certain obstacle to the state, to the admission of this hearsay evidence. Kappa says, before the close of the state's case, the state must make an application to court, which application will be debated by the state and ourselves, and the court will make a ruling to say, I want to make an application that this hearsay evidence and expounds that hearsay evidence clearly to be admitted against the accused before court. That was never done. The bus has already passed. Now, the submissions that we are making, my lord, to say that this application by the state must fail are the following. And I'm reading now from paragraph 7 of our heads of argument. We state, my lord, that from the principle enunciated in our arguments today, it is vividly clear that Exhibit JJ and whatever extracurricular statement that the state wants to cross-examine Mr. Sibiya on were made long after the offenses were committed. And we state, my lord, at the time the statements were made or allegedly made, the objectives of the alleged conspiracy as submitted by the state were no longer capable of being pursued. We submit, my lord, that such a statement or such statements are narrative statements because they are narrating past events after arrest. Because once we apply the Krulovich Wung Song, which say, and also Nkosi Mhlongo, which say, after arrest, any statement made is not an executive statement, but a narrative statement. And we say in this case, my lord, JJ and HHFF, whatever they want to introduce, my lord, and cross-examine on cannot be allowed because these are narrative statements which serve, if they indeed were made by Mr. Ntanzi and Mr. Sibiya, to incriminate the makers themselves, but not their co-accused. And I want to state, my lord, and I'll just briefly, as an anecdote, stop here. I want to be like Mr. Munisi, to say, if I say the statement made by Mr. Ntanzi, I'm in no way saying he made it. I'm saying in the context of this argument, because tomorrow I know it will be quoted to say, during argument on the 13th of 2000, Mr. Ramosepele stood here and said, you made a statement. So I don't want, on the right-hand side, when arguments come later, Mr. Ntanzi is held to the contents or the argument that I'm making specifically for this interlocutory application. And then I'm called never ever, everything never ever. And then paragraph 7.2, my lord, of our heads, we say we submit that to cross-examine Mr. Sibiya on the statements that they want to introduce, does not fall within the exception because the co-accused at the time of the trial within a trial, or even in the versions presented by their respective counsels, have never by word or conduct accepted the truthfulness of what's contained in the statements that the state want to adduce and to cross-examine Mr. Sibiya or any other witness on. Paragraph 7.3, we submit, my lord, that the conspiracy on or common purpose ends upon the completion of a crime, arrest, abandonment of the conspiracy, or separation of the co-conspirators. And any statement that is made thereafter, my lord, is detached. (7.4), as I alluded earlier to say, executive statements are made in furtherance of a crime. For example, when somebody says we are together, say, hide the weapon. We say, my lord, that confessions are made to explain or to justify past acts. They do not advance the common purpose. And we say further, my lord, that the common purpose exception should narrowly be applied, and specifically for matters that are done or said in the ongoing conspiracy, common purpose. They cannot be admitted against the co-accused under any guise, be it under Section 219, under the Hearsay Act, or under common law. Finally, my lord, we say that executive statements are not even made to police officers. Executive statements are made to co-conspirators. And for that, for those reasons, my lord, I say the application by the state stands to fail, as the court pleases.
So, in this clip, Ramosepele went deeper, saying that by dragging Sibiya into Ntanzi's alleged confession without the required hearsay application, Baloyi risks violating fair trial rights and contaminating the process. The punchline now here is that the state's own theory now works against them. They created a hearsay door, but never installed a legal lock. Now it's blowing open in their faces. So, state of strengthening the prosecution, the executive statement strategy has returned like a ghost, haunting Baloyi at the most critical moment. Ramosepele didn't just object, he exposed a foundational flaw in the state's design. The courtroom felt the shift. The judge took note, and the state suddenly found itself cornered by the very hearsay they once welcomed. When Ramosepele linked the state's current attempt to their earlier reliance on common purpose, a subtle wave passed through the gallery. That ooh energy you feel even when no one speaks. It wasn't chaos. It was a quiet shock, the kind of silence that tells you the power has just shifted. Was Ramosepele exposing a genuine legal flaw, or just playing a strategy to protect his client? If the state failed to make the required application on time, should the evidence now be excluded completely? Do you think Baloyi walked into his own trap with the hearsay issue? Why or why not? How do you think the judge will rule on this hearsay argument? Will it come back to damage the state even more? Leave your comments down below. Thanks very much for watching. Don't forget to like, share and subscribe. I'm Skybriedge. This fight is far from over. But today, Ramosepele proved that strategy cuts both ways. Until next time, goodbye.